Hello, hi, once again, this is yours truly, Clarice T, and it's noontime here in the Philippines, here in Lucena City, and it's the 12th of February 2025. It's a sunny day, and I know that many are rejoicing over this kind of weather after some dry and grim, downcast rainy days where the laundries cannot be dried out in the air, in the open air. So wherever I go during, you know, during my errands, that's the common comments that I get from people who really don't know me, but whom I exchange pleasantries. You know what? It's a contrast actually, because in the past, I felt like an invisible person. Invisible. Nobody can see me like when walking. But nowadays, I sure feel the warmth and just the greetings. Oh my, like, no, no, no. That's typically mine. They'd say, it's raining again. I do hope that it will stop raining. Our laundries are piling up. Or like in the jeepney, in the store when I'm out walking and I have to buy something. Yes, there's a common thread, common comment. The positive thing about this is that I don't feel invisible anymore and that I don't feel like a stranger and that I am truly, truly a part of the community and that we are one suffering from the dismal weather. My shoes get the worst of it, and yeah, it's so hard to walk with the intermittent rain showers. Well, anyway, I just want to proceed. It's yeah, I'm just amazed and I'm just so thankful that what I had taken for granted in the past while growing up, and then when things had changed, like when my circumstances had changed, and that I became an invisible person, just like a wind that passed by, something to be endured, yes, sometimes bad odor. The nose would go up and they would flick their nose in distaste. I could see that in the past. But nowadays, we have a common denominator, shared experiences. And I am somehow in our shared grief over the weather, we can have something in common finally. Anyway, I want to read this legal definition, which is quite remarkable at this point in time, because during the Amber Heard and Johnny Depp legal courtroom, which I don't know if anybody had stayed away from the courtroom being televised. And there's this lawyer, like I had surfed, I had tried the different takes of the different lawyers who tried to cover the Amber Heard and Johnny Depp trial in DC, and it struck me how the word, because he was the only one who had covered the deposition actually. So deposition, all the while I thought it was, like a coup d'etat, like a monarch being deposed. So when it was used in another sentence, of course, there is no escaping the different meaning. Deposed, a deposition, it's not the process of waging toppling a government, of being a revolutionary, trying to depose like a sitting governor or a president. And it says here, a deposition is it's the Cornell Law School, and it's immediately, I don't know, probably it has a good algorithm, because whenever I would research a legal terminology, it would usually pop out in the first page on the top searched information. Like, a deposition is a witness's sworn out of court testimony. It is used to gather information as part of the discovery process, and in limited circumstances may be used at trial. The witness being deposed is called the deponent. Then it says here, oral depositions, and now I realize it could be, I don't know, somehow I can surmise that what attorney Peter Tragos had shown in his channel, the deposition of, actually he covered it extensively, the deposition of Amber Heard, which was also used during the trial, but I had not seen the actual deposition being shown in the channel of other lawyers, and it caught my attention actually. So it can happen. Oral depositions. Depositions usually do not directly involve the court. The process is initiated and supervised by the individual parties. Usually, the only people present at a deposition are the deponent, attorneys for all interested parties, and a person qualified to administer oaths. Sometimes depositions are recorded by a stenographer, although electronic recordings are increasingly common. At the deposition, all parties may question the witness. Lawyers may not coach their client's testimony, and the lawyer's ability to object to deposition questions is usually limited. I could see through the confrontation that it is true, because both lawyers were really are at each other's objection and protection for their respective client, but I could see that they were at it because they had to observe the rules of the deposition. Anyway, going back, depositions are usually hearsay and are thus inadmissible at trial. There are, however, 3 exceptions to the hearsay rule that are particularly relevant to deposition testimony. The first is when a party admits something in a deposition that is against their interest, so a declaration against their interest. The second is when a witness's testimony at trial contradicts their deposition. The third is when a witness is unavailable at trial. See Federal Rules of Evidence, Article 8. So, as opposed to the written depositions, depositions may also be conducted by written questions. In this kind of deposition, the parties submit questions in advance. At the deposition, the deponent answers those questions and only those questions. Depositions by written questions are cheaper than depositions by oral questions because parties' lawyers need not attend. However, this method is typically seen as less useful because it is difficult to follow up on a witness's answers when the witness simply writes down their statements. Usually, parties use interrogatories instead of depositions by written questions. I saw this to be true. because one question and answer doesn't end there. What comes next, like, it's very spontaneous. So the lawyers for each party, for each side, was quite worried. Their attention was laser focused because they would interrupt amidst statement by Amber Heard, and it's very spontaneous. So actually, it's very revealing. That's why probably it's also it's less used unless those three elements are present. Pardon me, I'm just loosely using the terms that I hear from real lawyers, and it was a source of irritation for real lawyers whenever I would give something that I usually don't fully understand and I have a wrong application. Well, anyway, I am bringing this up because usually in a family court, or like in cases where identification, or any cases that sometimes couldn't be resolved in the first instance, or during the preliminary, it will involve the participation of the rest of the family, of the next of kin. And so this is in anticipation of the due course, which is that it is not just me as a person who should be giving a formal statement or like a position paper. Because somehow down the road, what the rest of the family, the next of kin, will say matter, because if it's in the interest, or in conflict with the interest of the family, like for instance in the SSS, my children, my daughters, were not allowed to pitch for me to be my reference in filing, in applying for a death benefit of my late husband and their father, paternal and biological, not biographical. Biological and paternal father, because they are parties of interest. So they cannot support me because they also represent the party who will gain. And so in matters wherein an interest, like an asset, will be removed from the family, in the line of family, they would be considered also as parties of interest. So down the road, it will not just be my formal statement, but there will come a time also that any statement they make should be duly protected, and that will cost money. Like here in this instance, the deposition that in the Amber Heard, it could not be, I don't know if my memory serves me right, but a postponement of a deposition could cost money because the lawyers are already getting paid. So and the postponement and the resetting of another day will double the fee, and somehow it's very expensive. So there's no going around it. There are costs involved in protecting the rights. And in our case, like in anticipation of the usual relationships that we have. So in any given day, I should expect that the statement of my daughters would come out like if we had a bad day, if we quarreled about something, they could say that, oh my gosh, mama is spendthrift. She doesn't value the money because she spent for this. And then during I could say the same thing. Oh, my daughters don't respect me because this happened. So it's very, sometimes it depends on the day when the deposition will be taken. But generally speaking, it should be taken like how the usual families are. And the main thing is the lasting effect of each other's testimony, whether for each other or how it will be interpreted. Like if I am really their mother, and how their experiences had been shaped with me in attendance. And then somehow later on, up, if like a claimants on like adverse claimants will formally assert for something that we have no at this point in time we cannot confirm, but based on the circumstances and incidences that had happened, we are yet to identify somehow and be told about any particular like property or the estate or the somehow a debt. So I thought that when the debtor has died, the insurance will pay for the debt, but actually it's not true for every debt. Like it can be passed on to the next generation, to the inheritors, to the heirs. So all these things, like what is the nature of the debt, what is the nature of the any case, legal case that will entail family like losses. Somehow the line of inheritance cannot take place because of the something that the ascendants had failed to settle. So these things happen. And in my mother's case, also in my father, that was actually what I had spent a good number of years trying to determine whether some either debt of gratitude or financial debt or any kind of being indebtedness or compromises or settlements that our late parents had not told me, but being the surviving heir, I should know about, right? So just for the process to move, so that there will be formal asking of question, like I had a legal publication when I had lost the papers, like in my publishing business. I had published my claims to it locally so that other claimants can find me and can know the process of reapplying for the lost documents as the owner, so that we could give each other the hearing if we find ourselves in the opposite, like we are adversarial claimants. So anyway, I know that like in preparation for that time when somehow my daughters could be asked the same question, like did your mother or did your father have another relationship aside from your parents, something like that. So what would be the basis for saying yes, and what would be the basis for saying no, there was none? What could be the basis for saying yes, there was a man in my mother's life? Yes, there was a woman in my father's life, because that will affect them. It even if not physically, even if it's just on paper, like technically speaking, because it happened when I was consolidating my identification, and I found myself single person without children. So another set of next of kins were actually had had me pinned down to whatever kind of circumstance I had during that time. So I had to sort it out. So when my daughters had reached the age of majority, and that there's a different roles that we are fulfilling in each other's life, and they have, as taxpayers themselves, their testimonies their testimonies should also be given, due protection. And somehow I am at it. I am at the helm of it. And so actually today is a very good day in preparation for my music releases. The house is full of dust. It's being repaired, and I have to take some time off also to attend to it. And getting myself back into the groove of my music, and hopefully with the first book that I am releasing through Amazon. No, I haven't forgotten about it, but it's in hindsight, the technical matters should be attended to first. Prevention is better than correction. So that's what I'm doing. So this is it for now, and thank you for being there. So it's the month of February, and so much has already happened. And bye for now.